That would be the matter of Carroll v. Trump. Counsel, whenever you're ready.
May it please the court.
Thank you.
My name is Mike Medeo, and I represent the defendant appellant, President Donald J. Trump. Today, this court deals with an issue of paramount importance. This court does not overturn the lower court's ruling. A president, for the first time in our nation's history, will be held civilly liable for his official acts. This would violate fundamental separation of powers principles and upend decades of Supreme Court precedent. To avoid this outcome, this court must affirm that presidential immunity is an absolute and non-waivable protection that serves to maintain the proper balance between the judicial and executive branches. We must also affirm that President Trump was acting within the outer perimeter of his official duties when he addressed the press and the nation with his public response to Ms. Carroll's allegations. Our first argument is that presidential immunity cannot be waived because it's an essential presidential prerogative that's deeply rooted in the constitutional separation of powers.
Counsel, how are the protections afforded by presidential immunity reduced by a finding that it is an waivable defense?
Reduced in terms of the...
So you're saying that the protections of presidential immunity need to be protected. My question is, how are the protections afforded by presidential immunity, how are they reduced if this court were to find it is a waivable defense?
The separation of powers would be weakened if we were to allow the judiciary to essentially pass judgment and exercise jurisdiction over the president's official conduct. I think it's very well established through a line of cases dating all the way back to the 1800s.
Why shouldn't the president be able to waive the defense if he or she wished to? I mean, there may be some strategic reasons not to assert it.
Well, I think, again, it goes back to the checks and balances, the separation between the three separate branches.
Well, should a president be able to waive it, to waive the immunity if he wanted to?
No, because it's a jurisdictional issue when the president is not able to. I mean, this goes back to the Holding and Phrase Act and ensure where they said that the political branches cannot choose to waive the separation of powers. They can't opt into an inter-branch conflict. And that's the whole purpose of the separation of powers, is to make sure that they stay separate and they don't intrude upon one another. And allowing one...
Well, isn't it, didn't the Supreme Court compare it to prosecutorial and judicial immunity, and aren't those immunities waivable?
The Supreme Court did compare them in one aspect, but the primary justification for presidential immunity, the Supreme Court made clear, was the separation of powers doctrine, which is not comparable to judges and prosecutors. The reason they compared to judges and prosecutors is that's a common law and public policy immunity that's based on the fact that they need to be able to do their job freely, but there is no separation of powers consideration when we're talking about judges and prosecutors. So I think, and again, in Nixon, the Supreme Court said that the most compelling justification for presidential immunity is the separation of powers doctrine. So I think that's a much bigger consideration than the common law considerations for judges and prosecutors.
Has any case held that presidential immunity is jurisdictional?
Well, there are many cases that have treated it as a matter of subject matter jurisdiction and dismissed it under 12b-1. There are also cases that have dismissed it under 12b-6 as a merits-based defense. So to this point, it's really been unsettled how courts have dealt with it. But again, the main case that has dealt with this, really the only binding precedent here, is Nixon v. Fitzgerald, where they specifically say that it's a jurisdictional question, that when presidential immunity applies, the courts don't have jurisdiction to hear the case. So the lower courts have dealt with it in a number of different ways.
Counsel, if it is jurisdictional, then in this case, your client filed a counterclaim of defamation against the plaintiff. If it is jurisdictional, should the trial court have thrown out your client's counterclaim for lack of jurisdiction?
Well, the counterclaim related to conduct that was fairly recent. I believe it was a statement made several months ago, So I think that would be separate, and apart from the conduct.
So whether or not the court has jurisdiction is decided temporally on the date?
Well, I think it's a different question whether the court has jurisdiction over conduct that would have been official presidential conduct as opposed to a counterclaim that relates to conduct that is in no way presidential and really raises no jurisdiction.
But doesn't that raise the issue that if we agree that presidential immunity is a non-waivable jurisdictional defect, as you're asking us to do, that if a president is sued and wants to litigate or bring cross claims, as your client did in this case, then the court would have to dismiss those actions for lack of jurisdiction, even if the president wanted to litigate that action?
No, I don't believe that's so, Your Honor.
How so?
The statements that are protected by presidential immunity are statements made by President Trump in June 2019. Those are jurisdictional and subject to presidential immunity is our position. Later statements made by Ms. Carroll in 2023 really have no connection whatsoever.
I understand that argument about the specifics. My question is a little bit broader than that. Assume that we were to agree with you. My hypothetical is, what if a president is sued and the president wants to not only litigate that lawsuit, but actually wants to bring cross claims within the same time frame? Are you saying that whether or not the president wishes to pursue that litigation, a court would have to throw it out as lacking jurisdiction?
Well, the president is immune from liability in his official conduct. I don't think there's anything precluding the president from bringing suits for anything that potentially relates to his official conduct. I think it's to protect him in his ability to do his job that he's immune for anything that relates to his official conduct. I don't think that would preclude any other actions emanating from that. And I'll move on, unless there are any other questions, I can go to my next point. And should this court find that presidential immunity is waivable, President Trump still should have been granted leave to amend to include as an affirmative defense. Notwithstanding the liberal standard under Rule 15, the lower court denied President Trump's request to amend his answer to include presidential immunity based on supported delay and the supposed futility of his argument. Respectfully, the district court failed to undertake the proper analysis in coming to this decision. First, the record does not support finding that there was any undue delay on President Trump's part.
The case was litigated for 3 years without the assertion of the defense. Isn't that so?
That's correct.
Yeah, and if that's the case, how was it an abuse of discretion for Judge Kaplan to say it's too late?
Well, in terms of raising, there's no prejudice. There's no additional.
Discovery was already conducted, largely conducted?
Right, and on the issue of discovery, since it was the Westfall Act issue at the time, Ms. Carroll had the opportunity, and in fact did question extensively as to President Trump's state of mind and whether or not he was acting within the scope of his employment, which is a narrower test than the other perimeter test. So any discovery that they needed to get, they had the opportunity to do so throughout the course of discovery. And I think it's important to stress here that the question is whether or not, when you're making an application for amendment, the question is whether there was any additional discovery that was necessary or any additional delay that would have been caused by the amendment, which here there was no additional delay and no additional discovery that was necessary. So really there's no prejudice to Ms. Carroll by simply allowing the amendment as it was sought. And then finally, even if presidential immunity is waivable, and even if the district court properly denied the request for leave to amend, President Trump still properly asserted the defense by subsequently raising it in his answer to Ms. Carroll's amendment complaint. Both sides here agree that the court's ruling in Gilmore v. this court's ruling in Gilmore v. Shearson and Shields v. City Trust govern here, but the district court overlooked this court's binding case law entirely and instead relied on an unreported Southern District case.
So I have a question on that issue. Let's assume, as you posited, if it is a defense and if it is waivable, had the amended complaint not been filed, would you then concede that the defense was waived?
If it is waivable and leave to amend was properly denied?
Yes. had the plaintiff not filed the amended complaint, and if it is a valid defense, non-jurisdictional and waivable, would you agree then, would you concede that your client waived it by not bringing it, that defense, until after the amended complaint?
I think in that circumstance, assuming that it is waivable and that there was no leave to amend that was properly denied, then I would say that the defense was not, properly raised at that point. But given the filing of the amended complaint under Shields and Gilmore, it was properly raised because those cases stand for the proposition that when an amended complaint is filed, it supersedes and replaces the original complaint, renders it of no legal effect. And there were only certain defenses that are not automatically provided upon filing of the amended complaint, and those are the defenses listed in Federal Rule of Civil Procedures called B2 and B5. And clearly, is not one of the defenses from 12B2 through 12B5. And even Ms. Carroll's position has been all along that it's a 12B6 defense. So even if the court were to accept that position, there's no question that it was properly raised under Shields and Gilmore in response to the amended complaint. So I think no matter how you look at it, whether it's that presidential immunity is a jurisdictional defense that's not waivable, whether the district court should have given us leave to amend to include it as a defense, or whether it was properly raised in response to the filing of the amended complaint, the defense was properly raised and was properly invoked by President Trump.
So can I ask you simply, I want to make sure I understand your argument. Even if we conclude that presidential immunity is waivable, you don't dispute that presidential immunity was waived, if waivable.
We don't dispute that it was not raised in the answer, the initial answer.
But in any event, you can move on to a second tier argument, namely that he could still assert presidential immunity at the time of the filing of the amended complaint. Is that right?
That's right.
All right.
And finally, as to the merits of presidential immunity, it's our position that presidential immunity is a meritorious defense here. The Supreme Court in Nixon v. Carroll established that the president is immunized from liability for conduct falling within the outer perimeter of his official responsibilities. Crucially, this test is an objective one. It's focused on the nature of the act in question, not the motive underlying it. The Nixon court expressly rejected a subjective test because it would subject the president to trial on virtually every allegation that an action was unlawful or was taken for a forbidden purpose, and that would deprive presidential immunity of its intended effect. As a result, presidential immunity can be overcome by allegations of bad faith or malice, and even alleged wrongful acts lay within the outer perimeter of the president's authority. Here, viewed objectively, there's no question that President Trump was acting within the outer perimeter of his office when he issued statements in response to Ms. Carroll's allegations. One of the statements was issued in an official White House press release, while the other two were given in direct response to reporters' questions at the White House. In addition to denying the substance of Ms. Carroll's allegations, the statements also addressed numerous highly political issues, including Justice Kavanaugh's confirmation hearing, the role of media in politics, the state of the Federal Reserve, and current foreign affairs, and they were all in response to questions from reporters. These statements were also issued in a defensive manner, given the serious accusations made by Ms. Carroll. President Trump, then sitting president, faced an unprecedented and unprovoked attack on his character. As both the leader of the nation and the head of the executive branch, he could not sit idly by and remain quiet in the face of these sensationalized allegations. He had a duty to respond. At a minimum, it was necessary to maintain the continued trust and respect of his constituents and to preserve his ability to carry out his responsibilities as president. In denying that the challenged conduct was within the outer perimeter of President Trump's official conduct, the district court deviated from the objective test required by Nixon. For instance, the district court accepted that President Trump was addressing a matter of public concern because the accusation had impugned his character and in turn threatened his ability to effectively govern. And it also accepted the premise that the president's speech on a matter of public concern comes within the president's official responsibility. At this point, the district court's inquiry should have ended. Nonetheless, it proceeded to perform the type of highly intrusive inquiry that the Nixon court expressly prohibited. The district court twice characterized the challenge statements as a personal attack against Ms. Carroll and found that the statements were made for an improper purpose. But by looking towards President Trump's alleged motive for making the statements, the district court failed to utilize the objective approach that is required for assessing the presidential duty.
Counsel, is this a good breaking point in your argument? I noticed you're almost 8 minutes over, and I will give you the time that you've saved for rebuttal, but if you have a few arguments to wrap up, just wanted to remind you that
Yes,
you're
that's
about 8 minutes over. Thank you.
All right, thank you.
May it please the court, my name is Joshua Matz and I represent plaintiff appellee E.G. Carroll. Virtually every argument that Mr. Carroll presented, both in his reply brief and the argument today, is mistaken. I'm going to go through them one by one to make sure that I address thoroughly each of the contentions that he set forth. I'll start with the point about waivability. As we explained at great length in our brief, the Supreme Court in Nixon patterned the law of presidential absolute immunity on existing traditions of absolute immunity, a tradition of doctrine that had long been understood to be waivable at the discretion of the person who is protected by the immunity doctrine. The presidents, the Department of Justice, and federal courts have overwhelmingly shared that understanding. I know sometimes there can be the effect where both sides say CEG, and they cite a few cases and it looks the same. It is decisively in our favor. We reviewed every single case since Nixon that cites Nixon for this proposition, and about 75% of them understand it as non-jurisdictional, which is consistent with the overwhelming practice of the executive branch and prior precedents. Now, against all, and I would add one last point to this, understanding it as non-waivable would mean that the judiciary is forcing presidents to allow the courts to adjudicate the outer limits of the presidential office in a circumstance where the president doesn't want them to do that, and where the president might, in fact, prefer, for strategic or other reasons, to litigate a case on the merits or to bring counterclaims, which Judge Thomas, you suggested. Now, against all of this, Mr. Trump advances essentially two arguments. The first is that because presidential absolute immunity implicates broader structural considerations, it cannot be waivable. That is hokum. The vast majority of doctrines that arise from the separation of powers are waivable. That includes the appointments clause, the recess appointments clause, the non-delegation doctrine, the joint commerce clause, many limits on non-article 2 tribunals.
Can I ask you if you would respond to Attorney Medeo's response to my question, and I pose the same question to you, which is, how are the protections afforded by presidential immunity reduced in any way by a finding that it is a waivable defense? His response, I believe, was that it undermines the separation of powers doctrine. How do you respond to that?
It does no such thing. I would say that if anything, the opposite is true. Finding that this is a waivable doctrine is to say only that it is within the discretion of the president to choose whether to assert it. Given that this doctrine exists for the purpose of protecting the president's discretion to make choices about when to raise the prerogatives of his or her office, it is perfectly consistent with the premises of absolute immunity to say that it's waivable. If anything, saying that the president cannot waive it, even if they want to, is what would aggrandize the judicial power at the expense of the executive power by unduly limiting executive prerogatives and autonomy, which is the very thing that this doctrine exists to protect. And it's hard to imagine that future presidents would suffer any chill in the exercise of their powers by virtue of this doctrine being waivable, since it's up to them whether to waive it. And presumably the next president will not worry about what would happen if it's waived, because that would only ever occur if they made a willful and voluntary choice to do so. So all it does is give them discretion. And so, when Mr. Trump says that because this arises from the separation of powers, it has to be waivable, that's not true. It's simply not true. Many separation of powers principles are waivable. That includes many doctrines that protect the prerogatives of the executive branch, like state secrets, like executive privilege, like immunity from compelled congressional testimony of the president and his senior advisors. And when Mr. Trump...
How do you respond to the argument that even if it is waivable, that once Ms. Carroll filed her amended complaint, that gave Mr. Trump the ability to assert the defense?
Absolutely. That argument is foreclosed by Gilmore, and that's the case for 4 separate reasons. And if the court will allow me, I'll walk through them one at a time. And I have to admit, the 12b-5, 2-5 reading was only given in the reply brief, so this is my first chance to respond to it. So I want to make sure I'm thorough about that. The first is that interpretation of Gilmore conflicts with Gilmore, because in Gilmore, what was at issue was a motion to compel arbitration. And a motion to compel arbitration, as this court has recognized in Barrows versus Brinker West Corporation, and as many courts in the Eastern and Southern districts have recognized, does not arise under Federal Rule of Civil Procedure 12b-2-5. A motion to compel arbitration is ordinarily understood as arising either directly under the FAA Section 4 or as arising under Federal Rule of Civil Procedure 12b-6. So Gilmore itself does not support the idea that this defense was brought back to life because it is not a 12b-2 to 12b-5 defense. The next difficulty with Mr. Trump's position is that it is inconsistent not just with the sort of mechanics of Gilmore, but with the language of Gilmore. What Gilmore fundamentally said is the filing of an amended complaint doesn't bring back to life anything that involves the court issue of a party's willingness to submit a dispute to judicial resolution. And it then identified the 12b-2 to 12b-5 modes of defense as just examples of that. But it is hard to think of something that is more obviously an objection to the submission of a dispute to judicial resolution than a claim of absolute immunity from suit in the first place. That's the second problem with their position. The third problem is that accepting their position would create an unequivocal and lopsided circuit split in which this court would be the only court to reach that conclusion. As we explained in our brief, multiple other courts, all of whom started originally with the Gilmore case, which then went to the 11th Circuit, then to the 6th and 7th Circuits, all of the other circuits that have reached this issue have said that when a party files an amended complaint, the only waived defenses that are revived are those that, in fairness, are necessary to meet some kind of fundamental change or novelty in the plaintiff's new allegations. Here, we raise that point in our brief, and Mr. Trump doesn't identify, and can't identify, anything that was new in our amended complaint that, as a matter of fundamental fairness, would require the resuscitation of his otherwise waived defense. And so if this court were to say that our amended complaint brought his defense back to life, it would be in direct contravention of the law of at least the 6th, 7th, and 11th circuits, based on a reading of Gilmore that is going to commend it from the text of Gilmore. The final point I make, there's one more, is that it would actually also be at odds with how this court has recently interpreted the law governing responsive pleadings and counterclaims. So there was a case called the Geico case, in which this court clarified is that when a party late in the case amends its complaint, the only counterclaims that may be raised in response to the amended complaint are those that relate directly to what is new in the amended complaint. You can't allege counterclaims that you could have alleged at the beginning of the ticket. And so, as part of a broader jurisprudence of how this court thinks about the response to amended pleadings, their position, I think, is foreclosed.
One of your claims on this issue was that your client was prejudiced because you were unable to conduct discovery on the issue of presidential immunity had it been raised 3 years earlier. What discovery would you have sought in terms of addressing the issue of immunity discovery?
I'm going to be very specific in answering that question. There are 3 forms of discovery, and I'm going to name names in these questions you would have asked. Before I do that, if you'll indulge me, I just want to set up why we would need this discovery. And I'm going to start in answering that with the Clinton versus Jones case, because it really comes from there. So in Clinton versus Jones, most of the claims involved acts that Mr. Clinton committed before he was in office. But there was one claim that Paula Jones alleged, a defamation claim, arising from Clinton's acts while he was president. Specifically, Jones alleged in her defamation claim that Clinton had directed his White House aides and the senior White House spokesperson to, quote, publicly brand her a liar by denying that the incident had occurred. For that claim alone, the Eighth Circuit noted that whether presidential immunity applies is, quote, not free from doubt. And the Supreme Court, in its opinion, did not reach that issue. It stated only that that defamation claim, quote, arguably may involve conduct covered by presidential absolute immunity. Clinton thus saw a close case, an arguable case, where the president, in coordination with senior White House aides and press officials, issued a bare denial of sexual misconduct while he's in office. Here, of course, Mr. Trump went well beyond that. He issued a series of attacks with highly inflammatory personal attacks on Ms. Carroll, and as far as we can tell from the limited discovery we have on this, did so with no involvement whatsoever of anyone in the White House.
Can you answer my,
Yeah.
I appreciate that you want to make these arguments, but if you would kindly answer the question that I posed, and if you need me to repeat it, I'm happy to do so.
I don't, and
Okay.
the reason I wanted to lay that out is to explain the legal relevance of what I'm about to describe, which is the discovery process. So first, in his deposition, we would have asked Mr. Trump for a lot more detail about the process through which he had issued and prepared the June 2019 statements. And we would have also have asked questions, which we didn't ask, about how that compared to the usual process by which he had issued other statements.
And what would that have, how would that have informed the argument?
It would have informed it, I mean, again, the standard for discovery is relevance. And under Clinton versus Jones, where the court characterized as an arguable case, the bare denial of a sexual assault allegation by a president who issued it in active coordination with senior White House personnel. We think it would have been highly relevant that Mr. Trump went well beyond a bare denial. He did so in a series of statements, and he did so apparently without any involvement or coordination of any other White House personnel. I think under the Clinton case, that would at least be relevant to the analysis. So we would have asked Mr. Trump, I have several more forms of discovery just to sort of lay out what we would have asked. We would have asked him how this process was similar to or different than his pre- and post-presidency process for making similar statements, responding to similar claims. And we would have asked him about inconsistencies between his deposition testimony and his written discovery responses. In those responses, he had identified 6 people, Dan Scavino, Nick Luna, Molly Michael, Oak Hicks, Derek Lyons, and Jared Kushner, as involved in the process by which he made these statements. But at his deposition, he denied all of that and insisted that the written responses didn't apply to him. That's the first category of discovery we would have sought. The second is that we would have pursued third-party discovery into some of the individuals that he had named. A course of discovery that we didn't undertake because we were anxious that doing so would invite concerns about executive privilege. That could significantly prolong and complicate the litigation. When all that was at issue was Mr. Trump's subjective mental purpose for the statements, which was the Westfall Act issue. That discovery seems to us not particularly important. If what mattered was the process and involvement of White House personnel and officials in making these statements, it would have been highly important. Finally, third, we would have probably sought expert discovery for prior senior White House comms and press officials that would have been relevant to the process for such denials. And we may also have pursued requests that we had contemplated sending to the National Archives for some of the internal White House documents surrounding these statements. Again, requests that we didn't pursue given the complexity of that procedure and given that we had not understood any of that to actually be factually at issue, when all that really mattered was his mental state. And so we had significant discovery, and I was one of the lawyers on the case at the time. These are things that we thought about in real time and made a choice not to do because the risk of prolonging the litigation and creating complex executive privilege rights did not seem worth it to us as measured against the absence of an absolute immunity defense, which Mr. Trump had not raised, had not mentioned in years, and at no point in the entirety of the discovery process did he ever indicate that it was irrelevant to the claims for defenses. I'd also note in that process, he threatened several times to raise executive privilege. So our concern about that was not speculative. It was very much in play. And in that respect, Mr. Trump's decision to spring this argument on us 3 years into the case, on the other side of the close of all fact discovery, was indeed prejudicial. And I would highlight that under this court's precedents, we don't need to show, we don't need to summon Mount Everest in showing how much prejudice we suffered, although I think it was real in terms of our ability to actually meet this issue. Because his delay was for 3 years, And because he has never, to this day, offered an explanation for it other than the Westfall Act, which I think turns him loose submitted, the burden for us is to just show that it caused us some prejudice. And I think we can meet that burden.
And there was an amendment sought in this case by the defendant to amend the defenses, to add additional defenses, correct?
That's right. While the Westfall Act was pending, just to sort of take this point on the floor, there are several problems with it, and that's one of them, Your Honor, which is while the Westfall Act appeal was pending, if Mr. Trump truly believes that all he was saying in the state court is that he was raising a temporary defense, but he was going to preserve his personal immunity for as soon as he was out of office. Well, as soon as he was out of office, Mr. Trump didn't raise it. Instead, at the first available opportunity, what he raised was an anti-SLAPP defense and counterclaim. And if Mr. Trump truly believed that the pendency of the Westfall Act somehow prohibited him from fully litigating the case as a party in his own right, or raising his own protections, there's no reason why he would have done that. There's also no reason why he then would have consented to have the case tried before there was a decision on this, or why he would have engaged in the entire discovery process. Because a party who believes that they are holding on to absolute immunity from suit does not behave the way that Mr. Trump behaved in this case.
Now, Mr. Madsen, I take it from what you have said that you would defend Judge Kaplan's dichotomy between, on the one hand, the statements made by Trump denying Carroll's accusation, which Judge Kaplan assumed fell within the so-called outer perimeter of his presidential duties, and on the other hand, Trump's attacks on Carroll. You would accept that dichotomy?
So for purposes of the merits of the presidential absolute immunity defense, just to make sure I'm
Yes,
safe,
sure.
yes, I would think that he would, Mr. Trump
Tell
has
me
a
how.
counter argument.
Tell me how we're supposed to draw the line between these two, between statements denying Carroll's accusations and Trump's attacks on Carroll with respect to the accusations.
Of course, I will answer that. Of course, the court will only reach that question if it concludes that Mr. Trump properly raised this defense. And that would be, I should say, a landmark opinion, because no court has ever issued an opinion holding that the president enjoys absolute immunity whenever they speak in public on a matter of public concern. The only opinion on this issue is Judge Mehta's opinion, which unequivocally rejected that proposition. But I do think the distinction that we've drawn is an intuitive one, and it's one that is grounded in the Clinton versus Jones case, as well as the underlying foundations of Nixon, which is that even accepting that the administration of government may in some circumstances require that a president responds to questions that are raised about his conduct before he came into office, a denial of those accusations addresses that concern. And I assume that that is why the U.S. Supreme Court and the Eighth Circuit in the Clinton case saw it as arguable and as made well that Mr. Clinton would have actually enjoyed an absolute immunity defense there. Although, to be clear, if Mr. Trump's rule was the law, they would have just said he had it. It wouldn't have been a close call. But they saw it as close to issue of bare denial. Here, I think the instinct is that there is no Article 2 function that is furthered or invoked or in any way advanced by a president engaging in repeated private attacks on a citizen, insulting her appearance, accusing her of making accusations against third parties that have no relevance to the matter at hand, and going beyond the denial. And I should say, I appreciate that there's an understandable instinct on the part of the court not to want to essentially line edit the president's statement, which parenthetically this court would not need to address if it concluded that Mr. Trump had in fact waived this. But if the court does get there, the concern on the opposite side of things is that if the president is free to say anything he wants in public, no matter what, because anything the president says is potentially of concern to somebody, or could be described as a response to something, then there is
And
no
what
reason
exactly is wrong with that?
I think what's wrong with that, and Judge Metz has described this at some length in his very thoughtful opinion in the Thompson versus Trump case, which I should note was argued on appeal to the DC Circuit and has been pending before them for quite some time. And so there are sort of briefing and resources on that that go beyond what the parties have offered in this context. But I think what's wrong with that is two things. First, it takes what is meant to be an immunity for certain official functions and essentially converts it into an immunity for the office as a whole. which Clinton told us is not how presidential absolute immunity works. And I think the second problem with it, practically, is January 6th and other circumstances like that. I don't think we're in the realm of hypotheticals in acknowledging that there are circumstances in which somebody who holds the office of the president may engage in public speech on matters that have nothing to do with the operation or administration of the government, that are not in furtherance of any federal policies or programs or take care duties, that cause significant harm to private citizens, where it would be in many ways inconsistent with living in a presidential rather than a monarchical system to say that they are wholly immune for their conduct. And if the court has any further questions?
Further questions from? Seeing none from my colleagues, thank you, counsel.
Thank you very much.
Counsel, to keep it fair, I'll give you an extra minute added onto your rebuttal time, because your counsel went more than 8 minutes over. All right, thank you, counsel.
Okay, so I'd like to address a couple of points. First, I'll just start with the amended complaint and asserting the defense in the answer to the amended complaint. Under Gilmore, again, we cited in our brief that there are many cases which have interpreted. The Gilmore case, first of all, does, and Shields as well, both specifically cite to the 12b2 through 12b5 defenses as being the only ones that are not automatically revived in response to the amended complaint. And many courts have interpreted that as well and agreed with that understanding. But even if that were not the case, there's really only two alternatives here. It's either that presidential immunity is a jurisdictional defense, which would be 12b1, which is what we are contending, or that it's 12b6, a merits-based defense. Under 12b1, obviously, subject matter questions is not waivable. And under 12b6, as the other side contends, it's very well established under Shields and Gilmore in those line of cases that any merits-based defense, if it's an effort to achieve judicial resolution of a controversy, that it can be raised in response to an amended complaint. So whether it's 12b1 or 12b6, either way, it was effectively revived in response to the amended complaint. And on to the next point, in terms of the waivability generally of presidential immunity, whether or not that protects presidential autonomy and undermines it, the other side that we have to look at here is exactly what's happened in this case. President Trump has now tried to raise presidential immunity 3 times and has been rejected by the court 3 times. And, when you're looking at how courts deal with the high deference owed to the office of the presidency and the separation of powers and, making sure that they're not intruding upon executive function, that's exactly the reason why it can't be treated that way.
No, go ahead, please finish.
The judiciary can't be allowed to take a position where it's foreclosing the president from waiving presidential immunity in a situation where he wants to, and he wants to be immune from liability. And now you're stuck in a position where the judiciary can continuously reject their attempts to raise this defense, which is a separation of powers-based defense.
Counsel, I'm trying to understand why your client did not raise the immunity defense initially. If it is, a defense wanting to be asserted, it's such an absolute defense, why not raise it immediately? But even if not, he sought to amend the answer and added an anti-SLAPP defense and a counterclaim. Why not raise the absolute immunity defense at that time?
The anti-SLAPP, that was a motion to amend the answer, but that was specifically taking advantage of the anti-SLAPP law. And that was the only amendment that was included in that motion, strictly anti-SLAPP. It was a very narrow amendment. There was no other defenses raised at that time.
But it was a motion to amend the answer to add a defense.
It was, that's correct.
So why wasn't the other defense added?
It was a motion to amend including anti-SLAPP, and that was the only purpose of the motion at that time. So it simply was not included at that time. And again, the other issue on discovery, again, just to reemphasize, the Westfall Act appeal was going on this entire time for years. And the central question in that appeal was whether or not it was within the scope of his employment. And that's a more narrow test, and it's importantly a subjective test as well. So the amount of discovery generally needed for a Westfall Act scope of employment test versus an immunity, absolute immunity, presidential immunity, objective test is going to be much more intensive. And in fact, Ms. Carroll did conduct much discovery on that issue, and in fact, much of that was the basis for their amended complaint, was that the questions they had to ask President Trump at his deposition about whether or not it was within the scope of his employment. So they certainly had the opportunity to obtain that discovery. They did obtain that discovery, and there certainly was no prejudice there in terms of raising the issue then. And again, finally, the last point that I'd like to address is, Judge Mehta, in his decision, was based on an entirely different premise when he was talking about the public speech of the president than we're dealing with here. That was based on, it was finding that it was based on his capacity as a candidate as opposed to president. It still found to be an official function. And in fact, in that opinion, he states that it's unquestioned that when the president speaks publicly, that's within the scope of his office. So here, there's not even any conceivable non-official function as there was in Thompson, where it was, that he could potentially be as a candidate as opposed to president. Here, he's in front of the press, he's answering questions, he's responding to this this important issue of public importance, and I think there's simply no question that he's acting as a president in that capacity. And the last issue, very quickly, is on divestiture. Again, that really comes down to a question based on Judge Kaplan's ruling of whether or not the appeal is frivolous, based on all the reasons that we have given here. We obviously believe that this appeal is not frivolous, and for that reason, that the district court has been divested of jurisdiction in the pendency of this appeal. And unless the court has any other questions, that's all I have.
I see no further questions from my colleagues. Thank you, counsel. That concludes this matter, and the court will reserve decision. Thank you.